Appeals court judges appear skeptical of Emoluments case against Trump. Washington U.A. panel of federal appeals court judges on Tuesday sharply challenged the legal basis for a lawsuit alleging that President Trump's profits from his luxury Washington hotel violate the Constitution's anti-corruption clauses. The three-judge panel of the United States Court of Appeals for the Fourth Circuit in Richmond, Virginia, appeared much less sympathetic to the lawsuit than the federal district judge in Maryland, who has overseen the case thus far. The suit, fought during the hearing, Judge Dennis W. Shedd, the panel's senior jurist, suggested the lawsuit seemed to seek to penalize the president for being a successful business executive. You even want him. The lawsuit, the first of its kind, asserts that Mr. Trump is violating the clauses in the Constitution that restrict federal officials from accepting government-bestowed financial gains or emoluments, other than their salaries. The Justice Department, although Judge Messett limited the case to allegations that Mr. Trump is profiting from foreign and state government guests who patronize the Trump International Hotel, he has allowed it to proceed to the evidence-gathering stage over vigorous objections by the Justice Department. Legal experts said the appeals court judges could make several moves in the president's favor, including allowing the department to appeal the whole case on an emergency basis or sending it back to the lower court with instructions to Judge Messett to reconsider the merits of some of his decisions. The Attorneys General for Maryland and the District of Columbia have asserted that the Trump Hotel is unfairly siphoning off business and damaging competitors in their jurisdictions. Judge Messett ruled, but Hashim M. Mupin, a Deputy Assistant Attorney General representing the federal government, told the appeals court judges that the president was immune from such claims. This case should be, he added, he is not any old inferior officer like the Postmaster General. They can't point to. The judges suggested that the plaintiffs seemed to have no clear notion of what exactly they wanted Mr. Trump to do, should he be found to have violated the emoluments bans. They repeatedly asked Lauren Ali Khan, the Solicitor General for the District of Columbia, whether the local jurisdictions were seeking to force Mr. Trump to sell the hotel, put the asset into a blind trust, or simply ban state and foreign government guests at that property. You filed the lawsuit and you don't even know what actual, real-world relief you think would satisfy your claim of violation, Judge Shedd said. When Ms. Ali Khan responded that the lower court would decide the proper remedy, Judge Paul V. Niemeyer scoffed. The district court is going to make this up. The third judge on the panel, A. Marvin Quattlebaum Jr., focused on what constitutes an illegal emolument. Courts have never before. The plaintiffs have argued that it should be defined as any government-bestowed profit, gain, or advantage, other than a salary. But Judge Quattlebaum, at a news conference after the hearing, the local attorneys general expressed confidence that they would prevail. Despite the reign of
raindrop, truck top, smoking, no cooking the hot pot, fucking on your bitch, yeah, that. Looking up, open the park,